What are the pros and cons of a customizable fund? Well, in this video, we're going to talk about what exactly is a customizable fund, what the pros are, what the cons are, what are the things you need to avoid in a customizable fund, and if you stick around till the end of the video, we're going to talk about some scenarios where a customizable fund really makes sense. So what is a customizable fund? Well, a customizable fund is when an investor gets to choose which asset in the fund to invest in. Let's say a fund has, 10 assets in it. In a customizable fund, me as the LP, as a limited partner, get to look at all of the assets in a fund and say, look, I want to invest in asset number 3, or I want to invest in asset number 7. I get to pick what asset I want to invest in, and I will get the profit and loss and the depreciation of that asset specifically, and none of the rest. This is different from a typical blind pool fund where the investors put their money in first, really betting on the fund manager as somebody who has the ability to go actually buy properties, but they invest in the fund blindly, and then the manager goes out and finds whatever properties fits within the fund criteria. The investors don't really get to choose what properties or what assets they get to belong to. They get to belong to all of them, which is actually one of the benefits because they get diversification. So there are a lot of pros to this kind of customizable fund, but also a lot of cons. So I want to go through both of them. But the number one pro is definitely cost. Unlike doing 10 syndications, for example, where you have to pay the cost of doing 10 separate securities offerings, with a customizable fund, you're primarily doing one main fund, which probably handles about 80% of all the compliance. And then each individual asset, you have a little bit of compliance, but it really is one major fund. And so the cost of creating a customizable fund is significantly lower than doing 10 separate syndications. Number two pro, I think, is the timing, right? When you pick an asset and you add an asset to the fund, you don't have to go through all the paperwork again, all the compliance stuff. And so you can get it done fairly quickly, and you don't have to wait for your attorneys and get everything in order. So that's a great benefit, especially if you, if your attorney's taking usually, 2, 3, 4, 5 weeks to get this done. It's kind of nice to get it done really quickly. I tend to not love that so much just because Premier Law Group tends to turn around things relatively fast. We usually have like a 1 week turnaround anyway. So that's probably less of a factor for our clients. But certainly if you're having your syndication attorney who's maybe not a specialist in syndication, they do a bunch of other things, and it just takes them 3, 4, 5 weeks, then maybe this is definitely a pro that you should consider. One set of docs, one set of main docs anyway. That's the big benefit of this in terms of you having to prepare one set of docs and then your investors having to review one set of docs. And the last one I have or came up with is that there's just one tax return, right? Everybody's a part of this fund. And so there's one tax return, 1K1 that all of the investors get. And so it's a pro for both. The sponsor doesn't have to put together 10 different tax returns, 10 different sets of K1s. And the investor doesn't have to get 2 or 3 sets of K1s if they're investing in 2 or 3 assets. They just get one K1. So that's kind of a nice feature. So those are, I think, the pros. If you guys that have been doing these, maybe you can drop in the comments the other pros that you guys see from your perspective, because I really do want to find out all the pros and all the cons. So when it comes to cons, I'm putting them into 2 categories. One is the additional disclosures that we have to provide to the investors every time we acquire an asset. And then the other category I'm putting into sort of that asset protection / LP exposure or risk exposure, okay? So the first category, which I think I've got about 4 of them, is the additional disclosures. Now, probably the most important part to remember is that under securities laws, you are required to give your passive investors the full set of disclosure information at the time of sale of the security. That's the point where we decide what are all the risks and disclosures that we need to provide that we are aware of, is at the time of sale, which is when people sign the documents and wire the money. So when an investor in a customizable fund, let's say you've already got 3 assets in there and I'm coming in asset number 3 and I'm like, I really like this third property for whatever reason, I want to invest in that one. Well, you as a sponsor have an obligation to provide me with the full set of disclosures at that point. And at that point, we've got more information than we did when we just did the fund at the beginning, 3 weeks ago or 6 months ago or whatever, because now we have a specific asset and we also have 2 other assets that are already in the fund, right? And so, for example, you're probably going to be providing your investors with a business plan, right? So you want to make sure that somebody's reviewing your business plan, make sure that that business plan is compliant, that has all the disclaimers, that has all the disclosures, that doesn't overstep things or doesn't go crazy. We spent a ton of time on the business plan in general. So we generally spend quite a bit of time on the business plan every time you have a new asset inside this customizable funds. Because, by the way, we do customizable funds. We've been doing quite a few of them lately. And so I'm not against it. I'm just saying that every time somebody comes in with a new deal, we are going to review whatever you're going to give them, a one sheet, a business plan. most clients will provide a full business plan. So we want to make sure that that business plan has been reviewed by us and we give all the disclaimers and all that stuff. The second one, of course, is to identify all the legal risks that you have an obligation to disclose to investors. And that's going to be risks on the property itself, right? You've identified a property, so you got to provide all the risk disclosure on that property. It's in a particular marketplace, so to the extent you weren't able to disclose the market in general in the master fund, you're going to want to talk about what the risks are of that particular marketplace, or maybe it's a specific city that you didn't disclose earlier. So what are the risks or representations you're making about the marketplace? And then also the lending product, right? What kind of loan do you have? Is it a bridge loan? Is it a floating rate? Do you have a rate cap? How long do you have the rate cap for? How much is the rate cap? Obviously, a lot of people are getting into problems with the rate cap. So that's something you need to be able to disclose to your investors at the point of sale when they're coming in. And then obviously all the uniqueness of that particular product, which is obviously, if the splits are different, your management fees, your asset management fees, anything specific to that particular asset, you want to make sure that you are disclosing. And then another one that you've got to keep in mind, I think a lot of people forget about this, is that you do have an obligation to provide your non-accredited investors who are coming in after the first asset with audited financials. People forget this because most of the time when we do a syndication, it's a brand new company and there are no financials, let alone audited financials, and certainly nothing that's material. But just like with any regular fund, one of the things is with a blind fund is that, fast forward 6 months, a year, 2 years, now I've got 2 or 3 or 4 assets in the fund. Well, now I have an existing asset. I have an existing LLC, an existing company that does have financials. And to the extent you are then offering non-accredited investors interest in the fund or in any of your, whether it's a customizable fund or otherwise, you have an obligation under Rule 502 to provide them with audited financials. And so, as you guys know, audited financials are kind of a pain. They're expensive. They're expensive when you have very little to disclose on the financials. They're usually around 10 or 15 grand, but certainly once you've got 6 months or a year or 2 years worth of financials, then it gets even more expensive. You're required to give them 2 years of financials at the time of sale. And if your company's less than 2 years, then just from the inception. So audited financials is another big thing to consider. So that's into the first category of just additional disclosures that we need to make to the investors. And again, those are just disclosures. We just need to list those. The second one is a category of the additional risk exposure that the investors have, that the LPs have. And this is kind of probably my number one beef in general. I really do feel that customizable funds don't really generate any benefit or very limited benefits to the LPs, certainly in relation to the risks that they're taking, the additional risks that they're taking on. For example, there's probably 3 categories of the risk. Number one is just obviously the asset liability risk. If something were to happen to the property, right? And again, we're talking about a property that you're not involved with, right? So let's just say hypothetically you're in property number 3 and something happens to property number 7. You're not getting any benefit from property number 7. You don't get any of the profits, any of the losses, any of the depreciation. You're here in my lane with property number 2. If something were to happen to number 7 and somehow the fund was responsible for that, well, I'm a member of the fund. So if there's a judgment against the fund as a whole, it's going to affect me as the passive investor because I'm a member of that fund. And to the extent the fund has to provide, a judgment or what have you, or there's something that they need to do, it's going to affect me. The good news there is that you can probably mitigate most of that by putting that asset into its own LLC, and then that LLC would be owned by the fund. So you get some kind of liability protection, but it's certainly possible and certainly happens quite a bit where, especially with single member LLCs, that corporate veil gets penetrated and they're actually able to reach the owners because of it's a single member. So that's just something that we need to disclose and let the investors know. Another issue is like, what happens if property number 7, something happens and investors lose all their money over there? So your asset's great, but for whatever reason, the property that was in another state that a bunch of other investors invested in, that goes south. There's an allegation that the manager and the fund mismanaged, and so now there's an investor lawsuit against the sponsors. They're going to name the fund as a defendant, and to the extent there's any recovery on the fund, you're a member of that fund. So it's going to affect, it's going to affect you. This is your company that you invested in. So investor lawsuit is another issue that we need to disclose. And then the last one is the lender, right? So that those properties are going to have to get a loan, right? And I've spoken with several lenders, and those lenders tell me, yeah, absolutely. The LLC that's going to own the property is obviously going to be the main borrower, but they're going to require the fund to either co-borrow or personally guarantee or however that's going to work. So to the extent that that project fails and now the lender comes after the property, and if there's nothing there, and if there's a claim against the fund itself, then again, that's going to affect everyone. So not the end of the world. It's just something that we have to disclose in the legal documents, and it's something that the investors just need to be aware of, and they need to make that judgment call, which is like, hey, what are the benefits that I'm getting from this customizable fund versus all the additional exposure that I'm getting, and is the risk worth the reward? I guess those are the main pros and and cons. Some of the things I think you need to avoid, I came up with a list of 4 things just sort of to consider or things to avoid. And the 4 things to avoid is number 1, avoid doing it yourself, right? This is something that I've seen some of the models out there where every time you have an additional asset, you really should have your securities attorney review that asset and make sure that you're providing them with all of the required financial disclosures and legal disclosures for that. Now, I've talked to a lot of the programs that are doing this, and I think, Jeff, you've got your hand up. You work with one of the providers. They actually encourage this. They encourage you to go talk to your securities attorney, whoever's preparing the docs, or your own, if it's a separate one, and make sure that they are indeed providing all the legal disclaimers. I think what a lot of people aren't taking that advice to go talk to the securities attorney. I think I would highly encourage you to go talk to and take advantage of that issue. Talk to the securities attorney every time to have an additional asset so that you make sure that you're fully protected there. The other best practice, I think, or things to avoid is after the first asset is in, I would avoid non-accredited investors. Not that you would try and avoid, it's just that you have to provide them with audited financials. I think the cost of that overwhelms the benefits and the savings that you're getting by doing a customizable fund. So you want to make sure that, yes, you can get your non-accredited during the first asset, because at that point, it's kind of like a regular fund. There are no financials at that point. It's a brand new company. There's no assets in the fund. And so I think for the first asset, you can probably bring in non-accredited. But then after that, once the second asset comes in, it's very difficult for you to bring in non-accredited if you've got to give them audited financials. So that's another thing to keep in mind. The third thing would be to make sure that each asset is in its own LLC. Again, for asset protection purposes, if some tenant slipped and fell or somebody got shot or all those nightmare stories you hear, that at least you've got a layer of protection, and and hopefully you can contain the liability to that LLC so it doesn't go to the other ones. It should work, but there's definitely jurisdictions that don't honor that as much, and it could get penetrated. But at the very least, you're maximizing your protection, not necessarily guaranteeing it. Unless you're doing a fund of funds. I think if you're doing a fund of funds, which I think a lot of people are, which means they're bringing money into their fund, and instead of buying an asset, a property, a piece of profit, they're going to invest in somebody else's syndication, which is great. Then I think you don't need to have an LLC, a separate LLC. I think having the fund itself own that LP interest is probably okay, because there's no liability, or very limited. You're a limited partner in that deal. So if something were to happen, the liability structure should stay in place. You could set up an LLC, but I think if you didn't want to, you could probably get away with that because it's going to be a passive investment. And the last one, if you are doing fund of funds, this is a general statement, not just for customizable funds, but you want to be careful or wary of simply relying on the offering documents from the underlying deal, because if for whatever reason something gets missed, remember, you didn't prepare those docs, your attorney didn't prepare those docs, but if those docs are missing something, right, they failed to disclose something, or there's something that they ultimately turns out they did wrong, you're going to miss that disclosure on your end as well. And so you just got to be super careful about that. We tend to recommend having the attorney review the underlying documents and making sure that, make sure that all the disclaimers are there, which is difficult because they're not your client. But at a minimum, you want to have some kind of a representation and warranty from the underlying sponsor that says, hey, these documents were prepared in full compliance with federal and state securities law. So at the very least, you have a counterclaim if you ever got sued because you failed to disclose something because the other documents failed to disclose, that you can point to them and actually get indemnified from that underlying sponsor to the extent they can, of course. Like, if they end up getting sued and they go bankrupt or whatever, you're responsible to make the disclosures to your investors. If you're going to rely on somebody else to make those disclosures for you, you're also going to be risking somewhat that if they don't do a good job under there or miss something, that's going to be imputed to you. And then the last thing I'll say is just when it really does make sense. And I think it makes a ton of sense. We just started doing one for a client who just has a ton of small entities where it just doesn't make sense to do a separate syndication every time. So if you're trying to raise 200 grand because you want to go buy a single family home, or you want to do a loan product, or that you're literally raising 2 or 3 or 4, or maybe even $600,000 per asset, spending 10, 15, 20 grand on compliance, it just kills the deal, right? And so a customizable fund at that point starts to make a ton of sense, because now I can raise 300 grand for this one, 500 grand for this one, 200 grand for this one. Even if you quote unquote screwed up, the worst, you're looking at 200 grand or 300 grand. You're not looking at millions and millions and millions. And so I think that's when it becomes really attractive. And that's where some of our clients we've been working with is because, people come to us all the time. It's like, I want to raise 300 grand. Well, it doesn't make any sense to do a syndication, a project specific syndication, but doing a fund, or now maybe a customizable fund, that starts to make a ton of sense. So if you enjoyed this clip and you want to see the entire episode, click here. And if you want to see other videos similar to this, click here.